Hello, this is Matt on the Moon Lambeau channel. Two attorneys within the XRP community have taken the SEC's best argument against Ripple and completely decimated it. I'm talking they have taken the damn thing to the wood chipper, inserted their best argument into the wood chipper, and it is now in a bazillion little tiny pieces and is effectively useless. So I'm going to share with you their thoughts in this video, and also, and it's on the same point actually, but there are 100 companies that I was unaware of. Well, at least I think I was probably unaware of most, if not all of them. I haven't gone through the entire list, but 100 companies cited by a Ripple employee that are utilizing XRP, and that is core to defeating this argument. So it's all on the same topic in this particular video, but this Ripple employee actually shared this information with attorney John Deaton. I'm sure many of you, probably most of you at this point listening, are familiar with him. He is taking the SEC to task. So he's attempting, and he's actually filed to make this be the case, to intervene in the SEC versus Ripple case on the behalf of 10,000 plus XRP holders. And ultimately, if he doesn't get what he wants and what we want, frankly, he will be filing a class action lawsuit against the SEC this summer. And there's like a time delay, which is why it would be this summer. I guess it would be June probably. I think it's the soonest it could happen here. But I do want to be clear before going any further that I don't have a legal or financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos as a super duper fun hobby on the topics of Ripple, XRP, and cryptocurrency in general, but that is indeed all that it is. And so here we're going to start off with this from John Deaton, and if you're not following him, I encourage you to do so on Twitter. He's at John, John his first name, middle initial E, and then last name Deaton, Deaton, and then the number 1. And he wrote the following. The SEC told the judge that it disputes XRP having any utility. The SEC's best argument against XRP holders' intervention is that we are investors, and Congress authorized the SEC to make arguments on behalf of investors, even if we disagree. And so think about it. Isn't it funny that the mission of the SEC is to protect investors? And so here you have a case where attorney John Deaton is seeking to intervene in this case with on the behalf of 10,000 investors that are pissed off at the SEC, and the SEC claims that they are protecting the pissed off 10,000 plus XRP holders. Yeah. clearly they are not protected. I don't feel protected. Do you feel protected by what the SEC is doing and going after Ripple? I sure as hell do not. And so he's making these claims, as you'll see, to an attempt to prevent John Deaton from being able to intervene legally in the SEC versus Ripple case. And he highlighted this image here, and you can see here's some text from them. And so the XRP holders, they're called the movants. And so you can see what he highlighted here in this little image. Movants may buy and sell XRP as a speculative investment. And then he highlighted, and so the fact that they even purchasing XRP as an investment, speculative investment, they highlight here. And this is from the SEC, mind you. Proof that defendants offered and sold XRP as a speculative investment. And he cites here, it's an improper basis to seek to intervene in this case. Intervention would serve no purpose here. That's right, XRP holders. The SEC's got your back. You don't need to intervene here. And then they wrote, defendants, with several law firms representing them, and that would be Ripple, of course, and Brad and Chris, anyway, are already making the arguments movements want to advance as to whether XRP was offered and sold as a security. And then they write this, which is just offensive. If movements want to advance the argument that they are investors, the SEC will make that argument. So there you go. It's an important legal distinction for whatever reason. If the purchase of XRP represents an investment, that's what the SEC from a legal perspective is arguing. So it's like, absolutely, yeah, if that's all it is, that's what this is all about, says the SEC here. So of course they'll look out for you there, right? And so then John wrote the following: with your help, I plan to take away their best argument by showing that it's not just XRP holders, i.e. speculative investors, that are seeking intervention, but also businesses, developers, etc., that utilize XRP, not as an investment, but as a utility token asset. And then he referenced in parentheses there the UK's classification. So he's talking there about the UK's Financial Conduct Authority, or FCA for short, which is highlighted that XRP has actual utility. So it's basically a hybrid token that, so it's like a utility token and also an exchange token. And that's how the UK is looking at it. And so then you go over here, and this is where XRP community member and attorney Arturo Portilla jumps in. So you got two attorneys here now. John E. Deaton started this thread with the following: XRP community. I need to find a business or developer or entity that uses XRP operationally other than accepting payments. A situation where the token is used not as an investment per se, but is utilized as a tool or as an interface, etc. Any ideas for me to contact? And so the first thing that popped in my head upon reading that, it might have been yours too, because outside of Ripple anyway, would be what Coil's doing. I think that outside of Ripple, their use case in coming up with a third form of web monetization is, I would guess, the most well known. That would be my for fun guess. And XRP is used in conjunction with Interledger Protocol to stream money in real time and pay content creators. So rather than having a paywall or a subscription model, people can get streamed money in real time as content is being consumed. So whether it's a video or a blog, as you're scrolling through and reading, money gets streamed actually in real time. And it's not possible without the blend of ILP, Interledger Protocol, and XRP. So that's the first one that popped in my head. And XRP, the price is what it is. It's not. XRP isn't there for some sort of speculative reason. It's there to serve a utility purpose, clear as day. And so this is where attorney Arturo Portilla jumped in and responded to John and wrote the following: "Do you mean on-demand liquidity, customers, and such?" And John wrote, "That's one category. The main purpose is looking for all non-investor use cases, possibly a developer who has been shut down because of the SEC case. Uphold or other exchanges are examples. Bottom line, someone or business in the United States that clearly can't be called an investor." And Arturo responded, "The thing is that once XRP is in your cold wallet, you can use it for in purposes." And so he wrote in purposes with in parentheses to indicate however many number of purposes. However many, there is no limit, right? Including non-investment ones. To get XRP into a self-hosted wallet, you need to go through an exchange. And so that's the point that I was making the other day. So when the SEC's claiming, oh, this is just for, you just want XRP back on these exchanges so that you can keep doing your speculating. I'm like, no. Yeah, people will speculate just like they speculate on gold and stocks and Bitcoin and just name your asset. But without the free-flowing trade of XRP, the utility that's derived from XRP becomes dead. It is no longer, like, if you shut down all the exchanges, XRP is not going to be able to easily flow. It can't even spread to additional people that might be interested should they find out about it in the future. And so, like, it's a serious impediment for the long-term viability of XRP and the utility that it's providing to the world. Right? And then Arturo wrote, that aside, companies like Coil, which I cited, Forte, XRPL Labs, and Exodus come to mind. There are also a myriad of institutional market makers and trading desks who provide liquidity to exchanges and over-the-counter transactions. They don't invest in XRP per se. They profit from trading spreads and pricing arbitrage. In Japan, SBI Group has used XRP to distribute dividend-like payments to shareholders, as well as to pay wages to esport gamers. SBI has used XRP as a marketing tool to incentivize the opening of trading accounts. FX Coin has used XRP to create derivatives and hedge currency volatility in order to settle corporate debt at future dates. Also, we should not forget that exchanges provide other kinds of services. They don't only provide the ability to buy, meaning invest, in cryptocurrencies. Amongst other things, exchanges provide wallets, custody, and P2P payments. The argument made by the SEC in XRP holders only wanting exchanges to relist XRP because they want to continue speculating with the price is just a reduction and an absurdum statement. I guess he wrote as reductio and absurdum statement. Maybe they want exchanges to continue supporting XRP because they want to be provided with such additional services and keep basic functionalities. Exactly, which is what I was getting at as well. And John Deaton saw that and wrote, "This is great stuff, Arturo. I might not be able to respond to all, but thank you. My assistant is keeping track of all responses to incorporate." And so it's just going through this. Is it not clear as day that the SEC's case has been completely decimated? Well, it's about to be. I'm going to highlight some more stuff here. We're not done. There's a lot more to cover here. But the SEC, it goes back to what I've been saying for a while now. I can't believe that the SEC believes what it is saying. I can't believe it. It's that illogical. Now check out this from John Deaton. The definition of an investment contract. Let's review not speculation or opinion, but the actual words used by the U.S. Supreme Court in the SEC versus Howey case. And here's a quote. An investment of money in a common enterprise with profits to come solely from the efforts of others. End quote. John continues. Now, the lawyer from the SEC makes a big deal about the speculative nature of the asset XRP. He claims that because we want XRP relisted again for the purposes of speculative trading, that is proof that Ripple sold investment contracts in the form of XRP. After reading that statement by the SEC, I reread Howey. The Supreme Court writes the following, and this is a quote, "And if that test be satisfied, it is immaterial whether the enterprise is speculative or non-speculative, or whether there is a sale of property with or without intrinsic value." End quote. Well, what's that? This just further decimates the SEC's argument. And this was SEC attorney Jorge Tenrero that was making this argument. And so here you go. If you're using Howey as the guide, Howey the guide says whether it's speculative or non-speculative, immaterial. Doesn't matter. You gotta love this stuff. I'm glad John found this stuff. And looked into this and shared it with everybody. And then he wrote, as you all know, I don't hold myself out as a securities lawyer, but I can read, and so can you. Your analysis is just as good or accurate as mine or the SEC's. The fact that I'm a lawyer does not make my opinion better than yours. I'm not special because I went to law school. Thus, just because this SEC lawyer says something, it doesn't make it accurate or even relevant. The same applies to me. The same applies to every other lawyer or CEO or YouTuber or even CTO. And so, of course, right there, I'm going to tell you, so this is the only thing wrong in this entire thread when he said that the same applies to even YouTubers. That's factually incorrect. So every XRP YouTuber, especially Moon Lambo, everything that they say is 100% accurate. And if you disagree, well, then you can just get out. Anyway, they wraps up by stating, unless that CTO is, of course, David Schwartz. He's just smarter than the rest of us. And that part is true. He is smarter than the rest of us. David Schwartz, of course, is Ripple's CTO and co-creator of the XRP ledger itself. Now check out this. I was unaware of this, and it's cool as hell, though. So when John Deaton, there's the tweet at the top of the screen here. He was asking for, for help collecting because he's putting together a list of entities that are utilizing XRP for utility purposes. Well, Ripple employee Matt Hamilton saw that, and he shared something that I frankly, I haven't seen before, or I just didn't retain the information if I ever have. And he wrote the following. John, are you familiar with Grant for the Web? It is a program to fund projects around web monetization. Here's a list of 100 companies/projects they funded. Each and every one of them uses XRP under the hood to allow users to pay content creators. And so he shared the link, and all I did was browse through it, but it's a massive list here. You can see me scrolling through if you're looking at your screen. And if you're not looking at your screen, don't worry, you're not missing that much. I'm just highlighting this. And so At the top, you're like, and this is still going, mind you, like the SEC going after Ripple is not slowing down the actual real world adoption of XRP. And this could not be more clear because, again, all of these have XRP in play. It's under the hood. It's being used. It's required, right? And so here you can see here's an entity called IGDAF, Diverse Game Developers Fund. And I'm not going to read the description of what they do. It's on your screen if you want to see it. But they got 505,000 United States dollars in February of this year, 2021. Here's another one, W3C, 268,000. There's all sorts of, I'm not going to go on, you kind of get the gist of it though, but all of this money is dispersed and XRP's at the core of it, and it's not for XRP speculative purposes. It's used in the plumbing to make all of this possible in terms of web monetization. And then Matt Hamilton, Ripple employee, continues. One example of the projects funded is Audiotarky, which you can see at audiotarky.com. You can also hear more about them on the live stream I did an hour ago with them. To be clear, these are not sites taking payment in the conventional sense, but they are utilizing the fact that XRP is decentralized, fast, cheap digital currency to enable whole new business models that are not possible with fiat currencies and conventional payment processors, none of which have anything to do with Ripple. How about that? And then he wraps up by stating, in fact, what is interesting is that, as I mentioned on the live stream, XRP is so transparent in its usage that many of those projects don't even know they are using it. All they know is payment is streamed directly from consumer to content creator. And that was fascinating to me. So how about that? I would say that the argument, their quote-unquote best argument that the SEC has, they're going to have to come up with something better than that, because this is not going to fly. I just can't imagine it. The facts are not on their side. You know, and so like if you got half a brain, it goes back to what John Deaton said when he's like, look, you don't have to be a lawyer to be able to read and understand something. I think that's true. What the SEC is arguing is incorrect. The idea, because they are, mind you, they're arguing literally XRP does not have utility. They dispute it. Well, here's 100 entities using it. Right there, just scrolling through my screen. That's 100. And I didn't even know about these before today. Look, you see what I'm saying here? There's all sorts of people using it. This is a truly global thing that is being adopted. It really burns my biscuits, guys. But I'll tell you what, I will wrap it up there. Thank you for stopping by, my friends. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.